It's day 26. It's Tuesday, June 3rd. Dr. Russell's on the stand for cross-examination. I imagine it will be a somewhat lengthy cross-examination based on what we've already seen from Prosecutor Hank Brennan. And I think Brennan probably feels like he scored some hits yesterday, so he's not going to just stop. He's got a whole different demeanor yesterday in his cross. We'll see what today's demeanor is like. Hopefully, court will just, I don't know, run kind of smoothly today. Who knows? We're like day 3 into the defense case and stuff has already been incredibly unexpected. And I guess that's what I should expect with this case, is that nothing is quite normal.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Oh boy.
Because she had, the defendant had undergone a very stressful event.
Brennan, warning, you just opened a box that you didn't want to open. I think he is leaning so heavily into Karen Read's statements to be the cure-all of this case. Did you hear the defendant make all these statements to the media? And did that change your mind? And she's like, absolutely not. Who do you think deals with people under stress more, Brennan or the ER doctor? Who do you think deals with people who are intoxicated more? People who have seen loved ones die more? Well, let's see how that goes for him. Bold strategy.
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that fabric.
You're aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. Like to approach, please.
Okay, come on up.
The prosecution has not called anyone about what is on the shirt. However, they did call the person who swabbed it. The victim's injuries were not swabbed. The clothing was swabbed. And we heard about the clothing being swabbed, but we did not see anyone who tested it, and there are no results in evidence.
Mr. Lessie, I'll hear you.
Thank you, Your Honor.
Oh boy.
Thank you, Your Honor.
There's a lot happening in this courtroom right now between the attorneys.
Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice.
A ton of shit has happened in this trial. And we have never seen the defense ask for a mistrial. And I have regularly said the defense does not want a mistrial because then it happens again. A mistrial with prejudice is a mistrial that cannot be retried. It is, we are granted a mistrial and this case is done. The hoodie was swabbed. We heard evidence that the hoodie was swabbed. The prosecution did not put in any evidence of that swab being tested. They only said it was swabbed. And now the question that Alessi is responding to of Dr. Russell was, did you consider or do you know that the hoodie was swabbed for dog DNA? Oh boy, is Alessi mad.
Based upon
That was an intentional question,
mention,
100%.
the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised.
All right, so the motion for mistrial is denied. Your rights are saved. And Mr. Brennan, you can continue with this line of questioning.
At the lunch break, day 26, we're 3 days now into the defense case, 4 witnesses. We are on the redirect of Dr. Russell. And we are getting into the different segments of redirect where we saw the prosecution go during cross-examination. This is after, of course, the defense argued for a mistrial with prejudice. The court denied the mistrial with prejudice and allowed the prosecution to continue to ask about this witness's consideration of the DNA results, though the person who tested the DNA and the DNA results themselves are not in evidence in this case, but allowed the prosecution to question the witness about the DNA results and whether or not she considered them. And she answered that she considered why the DNA results might show that there was no dog DNA. And she listed out a few reasons why the results might not show dog DNA. And that was the clothes were not tested for a substantial amount of time or swabbed for a substantial amount of time. The clothes were on the floor of an ambulance. And she listed off a few other things saying, this is why I was looking at whether or not this was a significant finding that would change my opinion about the injuries to John O'Keefe's arm. And she said, ultimately, the fact that there was no dog DNA found on the sleeve is not instructive to her because of all those other factors. We haven't gotten to that on redirect yet. I think that we will. The court also denied the Commonwealth's request to ask this witness about their rebuttal expert's report after a short voir dire of Dr. Russell. And when Alessi got up and argued before the court cut him off and said, no, I'm not allowing it in, Alessi was arguing this is the same circumstance as Dr. Welcher being questioned about Trooper Paul's report and the coroner, Scorty Bellow's report. This is the same thing. So she said she didn't rely on it. How can she be questioned about it? And the court agreed with Alessi on that and said, yes, you cannot question this witness about the rebuttal witness's report. So we are now into that redirect, asking Dr. Russell about what she considered, how and why, after we went through Dr. Russell reading in some of the points from the articles she relied on, talking about what you expect to see with dog bites and talking about the parallel nature of claw marks, talking about the mechanism of dog bites into peer-reviewed studies that were reviewed in medical journals. So now we are at lunch. I am waiting to see if the defense circles back in the area about Karen Read's interviews with media, because the defense started to ask about it and asked quite a few things about it and then started to ask for more explanation. There was an objection. They went to sidebar And then he came back and moved into asking about Dr. Welcher's slides, study, and how Dr. Welcher's positioned his own arm while dressed as John O'Keefe up against the back of the Lexus, and what types of injuries Dr. Russell would expect to see if the arm was hit from bicep down through wrist by the SUV, and what type of injuries she would expect there, because she said that wouldn't be a glancing strike because the arm is like squarely behind the vehicle. And she said she would expect to see significant bruising, lacerations, or broken bones. I expect we will see the Commonwealth then in their recross try to argue, but there are lacerations here, to which I expect her to say, well, that's not what any of the findings say. It says that these are abrasions, not lacerations, but I don't expect Brennan to skip over asking about that. You said it could be bruising or lacerations or broken bones. I expect that he will key in on that on his questioning when we get to recross. And yes, Brennan will get a recross. I'm surprised that after sidebar, we didn't see Alessi ask more about the area of grief that Brennan elicited the answer from in cross. I don't think Brennan expected that answer when he said, well, you didn't consider Karen Read's statements. I don't know how he couldn't, though. How do you not expect the answer when you ask why she didn't consider Karen Read's statements? I think that was a prime example of don't ask a question on cross you don't know the answer to, because he asked about it and said, why didn't you consider Karen Read's interviews? And she went thoroughly through, this is why I didn't consider them. It'll be interesting to see if Alessi is able to circle back in it or not. But how do you not expect that that's what's going to happen?
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant
Before
Buchanan,
it was
correct?
towed.
Correct. Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight,
Can you describe for the juror, by the way, which taillight are we talking about?
the right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
How did you
Can you
describe
tell us
it?
what that
Yep.
description is?
There was, it was damaged, the taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big,
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And
or so.
how wide?
That's a big piece.
Maybe that wide, maybe 3 inches, 2 inches, somewhere
Okay.
in there.
That's
I want to show you
a fairly
photo.
substantial
Your Honor,
size
with the court's
piece
permission, I would like to
missing.
show Exhibit 13. It's been previously marked. Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear taillight,
Of what?
the Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight the day I was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear taillight, please?
Okay.
That was what I was
Do you see
curious
the
about.
condition of that taillight
Is that
as
how much
it's
was
depicted
missing?
in this photo?
I do.
Sergeant Barros, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
What's
Or it
different about
absolutely
this
not.
photo,
Again,
sir?
that's two today.
That taillight is completely smashed out.
Does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence?
Objection.
Sustained. Ask it differently, Mr. Jackson.
Of course. Describe specifically,
that
other than the
taillight
fact
is
that
completely
it's
smashed
different,
out,
describe in
not
detail
how he saw
for the
it.
jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there. Towards that right side where that large chunk is, that's what was missing.
I'm going to hand you a green laser pointer.
So the middle section was
If
intact.
you can.
The section towards the side
displays,
was
one
not.
monitor directly in front of you and one to your right. If you could use the one to your right, it's a little easier on the
It would be
jurors.
so helpful if they also put up a picture of the entire rear of the Lexus so you could see the corresponding taillight on the other side to see how much of that is red. Did he testify in the first trial? Yes. I think on day 22 of the first trial, he testified he was called by the Commonwealth. And I don't think we got into this much detail with the photos in his testimony. That I don't remember. I remember him saying it was cracked with a piece missing. Now we are quantifying more what cracked with a piece missing means. He testified that the area he saw missing was where that red piece is on the side.
Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
So he's saying that red piece
Approach.
where the red connects to the top and the bottom on the far side or the outer side of the taillight, he saw that piece missing. And that seems to me, and I am terrible with dimension, so take this with all of the grains of salt, but that dimension of the gap between the two red parts seems to be the size that he indicated in court to me. Please let me know if that seems different to you, but that seems consistent with the size of the piece he saw from the outside of the vehicle, which is consistent with what Carrie said about seeing a piece missing. It was cracked with a piece missing, but not the whole taillight missing. I think when people keep saying not the whole taillight missing, this giant silver part is what they're talking about, the whole taillight. That's how I've read that testimony. I backed up just a little bit as they were getting into
Can
it.
you see what's depicted in the still image of that video right now?
I can.
I'm going to ask you if you'll turn to your right, concentrate on this area,
Zoom back.
this area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
Does it look clear? Does it look like it's shining red?
Looks clear.
The portion that is intact, does that appear to be brighter red?
Correct.
And the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase
It
that?
looks like, and this is the video from the door or doorbell camera at Karen Read's dad's house. It looks to me like the crack is right close to the top where the timestamp is. That there is a little swoop where there is not red, which seems to be the piece that he is describing.
Let's go back. You see the red?
Yes.
All right. Is that the condition of the taillight as you saw it on January 29th around 3:15 or 3:30 when you got to the location?
It was.
Your memory is that you discussed the distinction between that photo and what you saw at the last time you testified.
Objection.
I'm going to allow that.
And as you take a look at there, could you show me anywhere in your testimony, anywhere,
The objections are for Ms. State's testimony. I think that's what the objection is, because I remember him saying, not I didn't say that or I did say that, is I don't know if I was asked. That's my memory of the testimony. So that's why the defense is objecting, I suspect.
where you made any statement about that photo being inconsistent with what you saw in Dighton on January 29th, 2022.
I wonder if his answer is going to be, I've looked at my transcript. I was not asked. That would not shock me.
It's not in there.
Can I approach?
Yes.
I can put it back on. Thank you. respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why the academy, they teach you when you write reports to be as detailed as you can. To accommodate the fact that memories can fade. Right?
Correct.
You've seen quite a bit of information about this case and the issue regarding the taillights since you first made the observations back in 2022. Wouldn't that be fair to say?
Would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
I guess.
No, I don't want you to guess. You testified that you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in direct examination under oath, and you tried your best about things that just didn't happen, right?
Right.
Would you agree that you have some difficulty with your memory?
I'd agree.
I want to show you some evidence of that taillight before you had a chance to see it in Dighton. If we could have the ring video at 5:07.
He agreed. Whether you like Hank's questions or not, he agreed and agreed and agreed. Yes, the things I've seen have impacted my memory. Yes, I agree. I didn't testify to that in the first time I testified. Yes, I agree that this could have impacted it. At the end of the day on day 26, first, we learned that tomorrow is a half day. And second, we finally got to the end of the testimony of Dr. Russell after much back and forth on recross and redirect. And then we got into defense witness number 5, Sergeant Barros from Dighton PD. At the end of the day, the testimony with Dr. Russell is really the kind of testimony that is going to give the jurors who are like, hey, there's reasonable explanations for how this happened, room to argue. And there are going to be jurors, or there could be jurors that said, I don't know how to parse this or that because so much spaghetti was thrown at the wall in both cross and direct. They got into methodology probably more than the jurors ever wanted to hear. It matters to set up the battle of the experts with the rebuttal witnesses. But there were times in cross when Brennan was wandering into, but you can't determine that. And she's like, well, I've been an ER doctor. I can testify about injuries I've seen and wounds that I've seen. My criticism of the cross-examination for the Commonwealth is that they continued to throw out alternate theories instead of trying to narrow the witness down on why those injuries from their perspective came from a vehicle, not a dog. So getting into, but you can't tell if it's this or this or this or this or this, I don't think helps the prosecution move their case forward with that expert witness. They spent a significant amount of time saying, well, you can't determine if this is teeth or claws, and you can't determine this. And this article doesn't say what you say that it does. And we saw Brennan trying to really fight the knowledge base of the expert on, but this article says there's these factors and those factors aren't here. And she said, right, there aren't those factors in this case. They don't have to be in every case. I think what's difficult in the way Brennan cross-examines is instead of saying, so this article is something you rely on. This article says there needs to be these factors, punctures, tears, and those weren't here. He says, well, this article doesn't even lay out a standard. And then she says, I agree, there's different ways to approach this, but it's all pattern recognition. These articles show that you need to consider all of the injuries together. He said, so this doesn't even establish anything. And then he relies on the article to try to say, but these things aren't here. Pick one, and it might have more impact on cross. And I think it would have had more impact for him if he said, these articles you rely on say these things, puncture wounds to the skin, tearing, these things need to be present. I think she would have answered, no, they don't need to be present. Those things are present in extreme cases, which these were because they were deaths. But it would have at least helped, I think, Brennan make his point. We'll see. Again, the takeaway for the jury will be that there is an expert who says that the injuries to John O'Keefe's arm happened by a dog bite. And there is an expert for the Commonwealth that says that those happened from a taillight. I think the point that was difficult to follow for me the most from Brennan is when he was getting into the small and seen under magnification and microscope pieces of debris that were taken out of John O'Keefe's hoodie and shirt and asking about whether those could have caused the injury to John O'Keefe's arm. I'm like, where are we in this questioning right now? And Dr. Russell kept saying, but those wouldn't create linear, parallel injuries. And he's like, but there was all this debris. What in the world? So there was some rough cross-examination, I think, from Brennan. However, my opinion on that is different when it comes to Nicholas Barros. Nicholas Barros was from Dighton PD. He responded to Karen Read's father's home when Proctor and Trooper Buchanan arrived at Karen Read's parents' home to seize or take possession of Karen Read's SUV. And they had called Dighton PD around 2:30 in the afternoon on January 29th, 2022, and said that they were coming to Dighton to take that black SUV, and said as early as 2:30 p.m., this SUV was involved in a homicide and we were coming to take that SUV. And then reiterated that when they called around 3 and said that they were almost there. And then when Barros arrived at Karen Read's parents' residence, where we see that camera angle of the Lexus being loaded onto the tow truck, he arrived. Trooper Buchanan and former Trooper Proctor were still in a personal vehicle truck, and he met them there. They identified themselves. He spoke with Karen Read's mother. He talked about being around the Lexus for at least about 20 minutes and observing the back of the Lexus. He talks about writing a report and then seeing damage to the rear of the Lexus where the taillight was cracked and a piece was missing, but not completely damaged. He said it was about I think a dollar bill size damage, and then demonstrated the size piece that was missing out of the taillight. So cracked and a piece missing, but not entirely damaged. He was shown video by the defense of the vehicle being loaded onto the tow truck and said that looks consistent. And then he was shown the Sally port and said that that taillight in the Sally port is completely broken out or completely busted out. And that's not consistent with what I saw. In his cross-examination, I think Hank Brennan made some headway on this witness's memory. I do think that the point that they were referring to that being involved in a homicide investigation as of 2:30 p.m. is very interesting, especially when you have the coroner saying that they couldn't determine that that was a homicide. That timing I don't remember from the last trial, and that stuck out to me quite notably that they used that word with him based on his testimony. As we get into cross, I think Brennan made headway with that witness that will discount him for some. Brennan said, that's not what you testified to last time. You didn't say it was cracked with a piece missing and describe the piece missing, and you didn't describe how it was different from the picture in the Sally port is what he seemed to be referring to. And the witness said, I did distinguish between what I saw at Karen Read's parents' house and that photo. And Brennan showed him the transcript and said, where in it do you distinguish between the two? And he said, it's not in there. And then Brennan went down a line of questioning saying, so your memory isn't perfect as to what you testified to last time, and you don't remember if you distinguish the two, and your report is scant on the issue of it being cracked versus damaged. And then Brennan showed him the ring video from 507 and then the photo from One Meadows that comes from the dash cam and says, can you zoom in? Do you see that? Do you see that break? And do you see that picture? Isn't that consistent with what you saw? And he's like, yes. And I think a lot of the chat was like, they're the same picture. What are we talking about? But Brennan says that and I think asked well, wasn't the back of the Lexus SUV covered in snow? Wasn't snow packed into the taillight? So you couldn't have seen if it was missing. And the witness agreed with him. And then we got into a whole line of questioning about, but you met with the defense attorneys, you met with them at a hotel. Isn't that weird that you met with them at a hotel? And the witness was like, we met in a conference room. at a hotel. It wasn't weird to me. But the witness gave a lot of ground in the answering of his questions. I think some will see the witness as being incredibly forthcoming. Yeah, it's possible. I don't live under a rock. I've seen these clips all over social media. I've seen that tow truck video. I've seen the ring camera video. I've seen them more times than I can count. Some will be like, yeah, he was really forthcoming. He left open the possibility that maybe his memory was impacted by the things he's seen about this case on social media. And that's why he is now describing the missing piece of taillight different. Some might discount him entirely and say, well, you were very certain, and now your testimony is changing after you met with defense attorneys. Isn't that strange? You met with defense attorneys, and now you're like, no, it's a bigger one, and no, it's this, and no, it's that. At this point in trial, it depends on how people see the evidence coming in, because we have gotten 26 days in, and it really depends how people are seeing the evidence. And I think you're going to see the exact same witnesses argued different ways. Because when we see Alan Jackson get back up in redirect, he says, okay, well, you had a birthday 2 years ago. What day of the week was that on? Oh, you don't remember? Would you say you have memory problems? No? Okay. Do you remember being in Dighton? Do you remember seeing the car? Does it look like what was in the tow truck video and not what was in the Sallyport video? Okay, that's what you remember. And Brennan got up at the end and he said, isn't that photo with the broken taillight the same that you saw? And that would be the dash cam video, I think, because we didn't see it on screen. The dash cam video with the snow packed in to the taillight. That's how Brennan presented that. But will it matter? Because what we have is the tow truck video, the Sallyport photo, the video from 5:07 a.m. leaving One Meadows Ave, and then the photo from the dash cam at One Meadows Ave, and the jury can look at all of those themselves. So at the end of the day, you have someone who was in Dighton saying it was the same to me. The Commonwealth hasn't talked to me since the last trial. The Commonwealth hasn't called me. The Commonwealth hasn't asked me any questions. And the jury can see it for themselves. Because what he said was, it was cracked with a piece missing. But Brennan's cross-examination made him doubt his testimony, and he backed off of his testimony quite a lot. We will see what impact that has. Or is it just helpful to bring all those pictures up at the same time and let the jury see it for themselves? Is the jury seeing it for themselves more helpful than this witness's testimony? And is that really the point? That they've now seen all of those in sequential order? We will see. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.